All right, defense has informed me on this case he has no witnesses. The state is opposed to the defendant's application. Do both parties need a couple of minutes?
Yes, Judge, I guess it's a review. I was going to offer the criminal history.
Yes.
That's what that's like.
Okay. All right, defense, any witnesses or is just argument?
Just argument, Your Honor.
All right, you may proceed.
Yes, ma'am. As I look at his history, he's got an issue, and all of it seems to circle around drugs. The court did the thing I think that's helping him the most, regardless of the sentence today, and that was he needed treatment. And he got treatment, and he went to lifetime. I think it was 45 days there. And, Your Honor, since that time, my understanding, the reason he was put back in jail was because he was having some issues with his bail bondsman. And the conclusion, and the only conclusion I can reach about him, it's an excellent one. And that is the fact that treatment so far took on him. And we would submit to the court based on that this court consider probation.
Right off the bat, notice how the officer establishes the pattern. Asleep at the wheel, twice. This is crucial because in legal terms, repeated behavior can suggest recklessness, not just a one-time mistake. Pay attention. This is where the court starts building context.
And all the things that this court can use to make sure he performs well, or in the alternative, this is a cap, sentence him at the lower end of the cap. And once again, this is because, from what I can tell, lifetime took. And I know he's got a lot more work to keep it working. He's going to have a day-in-day life where you fight drugs, and there's a program out for them. He needs to make a meeting every day for the next 90 days, regardless if he's in jail or out of jail. Thank you, Your Honor.
All right.
Your Honor, you're asking that you deny the application since 8 years in prison. I think that the defendant's record is pretty clear that he has been given a chance previously for treatment. And not only does he keep possessing narcotics and controlled substances, but with felony convictions, he's also possessing firearms. And so, as part of the plea deal, we did waive the habitual enhancement. And what was listed on the indictment is a 2017 conviction for possession with intent to deliver.
Here's a classic courtroom primer. The judge breaks down the penalties and plea consequences. If you think a plea bargain is the final word, think again. The court can override it. This is a perfect example of how defendants need to understand that pleas aren't ironclad deals.
He wanted less than 1 gram, but in a drug-free zone. And then the second enhancement was for a 2020 felon in possession. And so I think there are programs to address drug issues, but there's no program to address somebody that just is committed to possessing firearms. For that reason, you're application.
All right, thank you. Is there anything you wish to say?
Yes, ma'am.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Johnny Richard Gonzalez.
All right. What would you like to say?
I'd like to say that lifetime recovery helped me a lot because I didn't know how to deal with none of my past issues. I was self-medicating, and with lifetime recovery, I learned how to cope. I learned how to ground myself and process the situations, and now I know how to cope with it. And I would like to continue my life with the tools that I learned at lifetime.
All right. State any questions?
So, Mr. Gonzalez, back in 2024, when you picked this case up, and then you have the other case that was from 2025, you're aware of those two charges.
Now the defense is highlighting treatment history. Watch the strategy. They are not denying past mistakes. They are framing it as rehabilitation potential. This is key in probation arguments. Courts love evidence of genuine effort to change.
Okay. And so you would agree with me that the facts and circumstances of both of the cases are kind of similar, correct?
Yes.
And that you were operating a motor vehicle both times, is that correct?
Yes.
And then both times you were asleep at the wheel, is that correct?
Yes.
And that's how the police officers make contact with you, correct?
Yes, ma'am.
Okay, and so in the 2024 case, you were also, well, I guess what was going on in your life that you were asleep at the wheel of a motor vehicle?
I was going on with family issues, and so I was self-medicating, and I was working as well. So I just didn't know how to cope with any of that stuff.
And when you say self-medicating, what were you using to do that?
I was using methamphetamines so I could still be able to work.
And then in the 2024 case, in that case, you were also in possession of a floodlight. Is that correct? The motor vehicle?
Yes.
Okay. And when did you complete lifetime recovery? Was that a part of your bond?
It was part of a pretrial. And I don't remember the date I completed.
And was that inpatient or outpatient?
But it was inpatient.
Okay. And do you recall how many days that was?
It was 45 days.
Okay. And then just regarding your history, you do have a prior history of drugs and also possessing a firearm, correct?
Yes, ma'am.
And
Just one question.
Mhm.
You understand for the rest of your life, especially for the first 2.5 years, you need to make a meeting every day, sometimes more than one day.
Yes, sir.
That's the only way you know you can make it.
Sir.
Thank you. Pass the witness, Sean.
All right, I have a few.
Notice the defendant's personal testimony here. Lifetime recovery clearly had an impact, and courts take this seriously. This isn't just feel-good talk. Judges consider these insights when evaluating the likelihood of reoffending.
There, because I was self-medicating and stuff, but everyone's arguing over the property and stuff, and just,
Which people do when there's no will.
yeah.
That's why everybody should have one.
Mhm. And so when my father passed, my brother ended up making a will and put everything in his name. So I was in the streets, so I was just,
Well, that's sort of a crime, maybe. I don't know.
yeah.
Somebody just can't make up a will after somebody passes and sign off on it.
So like, I was
But it's been not happened.
I was just trying to survive, but I didn't know how to cope with none of that stuff before. I didn't know how to ground myself and process it and use my brain. So, but I learned a lot when I was in Lifetime.
What did you learn at Lifetime?
I learned how to slow down and process the situation, and instead of taking off to the races, no, I ground myself and find coping skills as working out or the Bible and working, just staying busy and doing meetings and just speaking about my problems.
Mm-hmm. Do you have any children?
Yes, ma'am.
What are their ages?
I have a 15-year-old.
Here comes the pivotal moment: deferred adjudication versus straight prison time. Audience, this is the classic risk vs reward scenario. The judge is giving a lifeline, but only if the defendant sticks to treatment. Miss a step, and it's back to full-range sentencing.
All right. So here's the thing. I'm going to give you a choice. Some people I can give choices. Some people I can't give choices. Some people will come before me and they'll say, hey, you just gave this guy a choice. Why can't I have a choice? And I'm like, because you're charged with murder, you know. So I'm going to give you a choice. Here is your choice. One, are you deserving a deferred adjudication? Absolutely not. But I will give you deferred adjudication. And what I can tell you about deferred adjudication, the state is asking that your punishment be capped at 8 years. If you are unsuccessful at deferred adjudication, you will be looking at the full range of punishment. That's 10 years, right? But I'm telling you, with deferred adjudication, you're going into inpatient treatment. You're either doing inpatient treatment or felony drug court. Felony drug court, they may or may not be able to accept you. We can see. But if felony drug court doesn't accept you, inpatient treatment. There's no coming back to me saying, Judge, it's taking too long for inpatient treatment, because that's where you would be going. Or this is your other option. I will find you guilty and I will sentence you to 5 years in the prison. Which do you prefer?
Inpatient.
All right. Then this is what the court will do. Counts 1 and count 2 will run concurrently. There's to be regular reporting by Zoom or in person. There's to be regular random UAs.
Final wrap-up from the judge. It's not just rules and fines, it's life advice. Judges often double as tough coaches here. Build trust, make daily decisions wisely, and remember who you're accountable to. This is what real-world probation looks like, folks, not just court theatrics.